Sam borrowed his friend Alex's expensive video game. He promised to take good care of it, but unfortunately it got damaged while it was in his possession. Alex is upset and demands that Sam pay for the repairs, which cost rupees 6,000. In this situation, Alex is like the plaintiff in a lawsuit. Alex is making a claim against Sam, saying that he owes him rupees 6,000 for the damage to the video game. Now here's where the counterclaim comes in. Suppose Sam remembers that a few days before lending the video game, Alex borrowed Sam's laptop. When he returned it, the laptop had a cracked screen and Sam had to pay rupees 3,000 to get it fixed. So Sam also has a valid reason to sue Alex in return because he damaged Sam's property. In this case, Sam's counterclaim would be rupees 3,000, which is the cost of repairing his laptop. This counterclaim allows Sam to bring up his side of the story and seek compensation for the damage to his property, just like in a legal case where the defendant responds to the plaintiff's claim with their own counterclaim. The court would then decide how to handle both claims. Now let's have a look at Order 8, Rule 6A to 6G of Civil Procedure Code that refers to counterclaim. Order 6A. The defendant's right. If a person is being sued, being the defendant, he has the right to not only defend himself but also to make his own claim against the person who sued him, being the plaintiff. This is called a counterclaim. But wait, timing matters. The defendant can make this counterclaim either before or after the suit is filed, but before the defendant has delivered his defense or before the time limit for delivering his defense has expired, and the claim must be within the court's pecuniary limits. Effect of counterclaim. This counterclaim is treated like a cross suit within the same case. The court can make a final judgment on both the original claim made by the plaintiff and the counterclaim by the defendant. Plaintiff's response. The person who started the lawsuit, being the plaintiff, also has a chance to respond to the defendant's counterclaim by filing a written statement within a certain period set by the court. The rules. The counterclaim is treated as a plaint and is governed by the rules applicable to plaints. Rule 6B. Counterclaim has to be stated. If the defendant has a reason to sue the plaintiff in return, the defendant should clearly state this reason in his written statement to the lawsuit. Rule 6C. Exclusion of counterclaim. If the plaintiff thinks that the defendant's reason to set up counterclaim should be dealt with in a separate suit, he can, before issues are settled in relation to the counterclaim, ask the court to exclude it from the original suit. The court will then decide whether it should be handled separately or together with the original suit. Rule 6D. Effect of discontinuance of suit. Even if the plaintiff's lawsuit is stayed, discontinued, or dismissed, the defendant can still pursue his counterclaim. Rule 6E. Default of plaintiff to reply. If the plaintiff does not respond to the defendant's counterclaim, the court can decide the case in favor of the defendant or make a suitable decision as it deems fit. Rule 6F. Relief to defendant where counterclaim succeeds. If the defendant's counterclaim is established and there is still any balance money to be paid to the plaintiff or defendant, the court can decide which of the parties is entitled to such balance. To explain this, suppose if the defendant succeeds in establishing his counterclaim for recovery of rupees 1 lakh and the plaintiff in his original suit claimed from defendant for recovery of rupees 2 lakhs, the court will now reduce the claim of plaintiff to be rupees 1 lakh, and if the plaintiff's suit succeeds, ask the defendant to pay only rupees 1 lakh to the plaintiff. Rule 6G. Rules for written statements to apply. The same rules that apply to written statement of defendant also apply to response filed to a counterclaim. In simple terms, if someone is sued, they can not only defend themselves but also ask for something from the person who sued them as long as it relates to the case and is within the pecuniary limits of the court. The court can consider both sides of the story and make a final decision on everything in one go.